The Supreme Court chamber was engulfed in silence as Associate Justice Amy Coney Barrett began reading the majority opinion in the landmark case United States versus Amazon Technologies Incorporated. Her voice, steady and authoritative, echoed through the solemn grandeur of the courtroom, each word captured by waiting cameras. In light of the extraordinary scope of data privacy violations and the calculated evasion of existing regulatory oversight, Barrett declared, "This court holds Amazon Technologies accountable for statutory damages totaling $1 billion. Her delivery was firm, unmistakably final. Barrett continued, condemning the mass harvesting and commercialization of user data without informed consent, labeling it a breach of federal privacy laws on a scale unparalleled in the annals of American jurisprudence. Gasps and murmurs rippled through the gallery. Legal analysts traded astonished looks. Not since the early days of digital antitrust litigation had the court imposed such a sweeping judgment against a technology titan. DOJ attorneys appeared stunned by the magnitude of their win, while Amazon's legal team quickly convened in tense, whispered discussion. But the real shock was yet to come. Within 48 hours, Jeff Bezos, Amazon's founder and executive chairman, would unveil a counterstroke so bold and surgically strategic that it would not only undermine the billion-dollar ruling, but also redefine the dynamic between Silicon Valley and the nation's highest court. What began as a decisive legal rebuke was about to evolve into a power play of historic proportions, one that would leave the judiciary, the tech world, and the American public utterly speechless. Before we unpack this remarkable legal showdown, don't forget to subscribe and turn on notifications so you never miss our breakdowns of the transformative moments reshaping America's legal and corporate landscape. Since her contentious confirmation in 2020, Associate Justice Amy Coney Barrett has emerged as one of the Supreme Court's most disciplined and intellectually rigorous voices. At 52, the former Notre Dame law professor has consistently defied early assumptions that she would serve as a predictable partisan. Instead, Barrett has cultivated a judicial reputation rooted in strict textualism, one that has, on occasion, led her to surprise both critics and supporters alike. The Amazon Technologies case marked a defining moment in Barrett's evolving jurisprudence on digital privacy, a realm increasingly central to the American experience. As emerging technologies reshaped daily life, Barrett worked to develop a refined legal framework capable of applying constitutional principles to complex data and surveillance questions. Her academic foundation uniquely equipped her to navigate the challenging intersection of traditional legal doctrines and the relentless innovation of the digital age. To Barrett, this case was never just about one tech company. It was about preserving the judiciary's relevance in an era where corporate power often outpaces governmental regulation. If the courts failed to draw clear legal lines for tech giants, the credibility and authority of the judicial system would begin to erode, potentially becoming obsolete in governing the most consequential forces shaping modern life. On the other side of this legal battle stood Jeff Bezos, the 60-year-old founder and executive chairman of Amazon. Having transformed an online bookstore into one of the most powerful corporations in history, Bezos stepped away from the CEO role in 2021 but remained firmly in command of Amazon's strategic direction. With a personal fortune north of $140 billion and a parallel ambition to explore space through his company Blue Origin, Bezos wielded resources and influence that rivaled many governments. But it was not just his wealth that made him a formidable opponent. Bezos' reputation as a master strategist, rooted in his day-one philosophy of continuous reinvention and obsessive customer focus, gave him a unique edge. Time and again, he had turned challenges into catalysts for even greater expansion. Although the court's billion-dollar judgment was substantial, it represented a mere fraction, less than 1%, of Amazon's yearly revenue. The real threat wasn't financial. It was legal. If the Supreme Court's interpretation of privacy law became the new standard, it could unravel Amazon's data-driven business model and open the floodgates for similar lawsuits across the tech industry. Legal observers expected Amazon to file appeals, stall enforcement, or turn to legislative lobbying. What no one foresaw was Bezos personally stepping into the fray with a countermove so unexpected, it would not only contest the financial penalty, but also attempt to rewrite the rules governing how Silicon Valley and the Supreme Court would engage for generations to come. As legal analysts across the nation pored over Justice Amy Coney Barrett's sweeping 57-page opinion, a very different kind of meeting was underway at Amazon's Seattle headquarters. Jeff Bezos had called an emergency strategy session, not only summoning Amazon's top legal advisors, but also bringing in prominent constitutional scholars, data privacy ethicists, and experts in regulatory policy. The composition of the room signaled something unusual. Bezos wasn't preparing for a routine legal appeal. He was preparing to redefine the battlefield. Justice Barrett's opinion reveals a deep misinterpretation of how modern data systems actually function, Bezos reportedly told those gathered. But within that misunderstanding lies an opportunity, an opening to reshape the entire narrative. Even as headlines blared about the record-setting $1 billion penalty levied against Amazon, Bezos's inner circle had already begun executing a bold, multi-pronged response. The plan, as ambitious as it was unconventional, would soon leave both supporters and critics of the court's decision equally stunned. Barrett's ruling had meticulously unraveled Amazon's legal defenses, citing damning internal communications that demonstrated deliberate overreach in user data collection, often well beyond what had been disclosed in the company's stated privacy policies. Particularly scathing was her criticism of what she termed notice theater, the deceptive practice of hiding crucial privacy terms in dense, unreadable service agreements. The assertion that consumers gave informed consent collapses under the weight of intentional obfuscation, Barrett wrote. Constitutional liberties are hollow when the ability to choose is erased through deliberate complexity. Her opinion was a judicial thunderbolt, an unambiguous warning to big tech that the era of burying rights beneath legal jargon might finally be coming to an end. But in Bezos's war room, it was also seen as a call to arms, a rare moment to not only push back, but to potentially pivot the national conversation on privacy, power, and digital consent. The Supreme Court's opinion attracted support from an unlikely alliance of justices. Both liberal figures like Justice Sotomayor and conservatives such as Justice Gorsuch aligned with Barrett's textualist interpretation of the relevant statutes. Only Justices Thomas and Alito dissented, asserting that the court had ventured beyond its constitutional role and into territory that rightly belonged to Congress. As legal commentators debated the potential ripple effects of the decision, Amazon's public response was notably subdued. The company issued a terse statement expressing disappointment and a vague promise to evaluate all available options. That muted reaction, so unlike Amazon's typically assertive posture, should have been the first sign that something far more calculated was underway behind the scenes. Exactly 48 hours after the ruling, Jeff Bezos broke the silence. In an extraordinary move, he released an open letter, simultaneously posted on Amazon's homepage, published as a full-page ad in major national newspapers, and promoted across digital platforms. But instead of launching into a combative rebuttal, Bezos opened with a shocking admission. Justice Barrett's assessment of current privacy practices is fundamentally accurate, he wrote, instantly seizing national attention with his unexpected concession. The digital data ecosystem has outpaced both our regulatory structures and the public's understanding. Rather than challenging the court's findings, Bezos made a sharp and strategic pivot, one that would completely shift the public dialogue. Amazon will not merely comply with the court's decision. We will go beyond it, the letter continued. Today, I am announcing the creation of the Digital Rights Foundation, an independently governed body endowed with $5 billion, 5 times the value of the court's imposed penalty. Its mission will be to help define and defend data rights in the 21st century. The move sent shockwaves through the tech, legal, and financial worlds. Amazon stock, which had dipped following the verdict, surged as investors recognized the visionary nature of Bezos's maneuver. By voluntarily exceeding the court's judgment, he had reframed the company not as a reluctant defendant, but as a pioneering force in digital ethics. Yet the most surprising element of Bezos's announcement had not yet been revealed, and what followed would reshape the relationship between technology, governance, and civil liberties in ways no one could have predicted. I am extending a formal invitation to Justice Amy Coney Barrett to serve as honorary chair of the Foundation's Judicial Advisory Board upon her retirement from the bench, Jeff Bezos announced, delivering the final, unexpected twist of his open letter. Her intellectual discipline and unwavering dedication to foundational legal principles make her exceptionally well-suited to help craft a durable framework, one that safeguards individual rights while encouraging ethical innovation. Though Barrett, still an active member of the court, was ethically barred from accepting or even responding to such an offer. Bezos's move was a masterstroke in strategic optics. It subtly reframed Barrett not as Amazon's chief judicial critic, but as a respected potential partner in addressing one of the most urgent issues of the digital age. The overture was more than symbolic. It was a calculated effort to pivot the conversation from adversarial litigation toward collaborative reform, subtly casting the court's ruling not as an end, but a beginning. The ripple effects were immediate and seismic. Within hours, the White House, key congressional figures, and major consumer rights organizations scrambled to issue statements. What had appeared to be a crushing legal defeat for Amazon was rapidly morphing into a public relations and policy win. The Department of Justice, still celebrating what it had hailed as a watershed victory in digital privacy enforcement, now found itself on the defensive. The narrative was slipping, and Amazon was writing the next chapter. Justice Barrett, bound by judicial ethics, offered no public response and maintained her customary silence on ongoing matters. However, insiders close to the court suggested she was increasingly uneasy. Some legal observers viewed Bezos's gesture as a veiled attempt to blur the line between judicial independence and corporate influence, raising serious questions about the boundaries between private power and public authority. As media coverage fixated on Bezos's bold proposal, Amazon quietly executed the next phase of its plan. The company filed a formal motion with the court, not to overturn the $1 billion judgment, but to modify how the penalty would be administered. Rather than submitting the funds directly to the U.S. Treasury, Amazon proposed the creation of a court-supervised restitution fund. This fund, they argued, would provide direct compensation to affected consumers while also supporting research into privacy-enhancing technologies. It was a brilliantly engineered legal maneuver. The proposal placed the court in a precarious position. To reject, it would risk appearing indifferent to the actual victims of data violations, prioritizing abstract enforcement over tangible redress. To accept it, however, would lend credibility to Amazon's broader initiative and strengthen the company's post-ruling narrative that it was not merely complying with the law, but taking leadership in shaping the digital future. Either outcome would shift the balance of power, blunting the moral clarity of Barrett's original opinion while elevating Bezos's vision for a privatized, innovation-led model of accountability. As legal analysts across the country debated whether Jeff Bezos had cleverly outmaneuvered the Supreme Court or instead deepened Amazon's legal entanglements, a larger confrontation began to take shape. It was no longer just about a billion-dollar fine. The battle lines were now drawn between the enduring authority of the judiciary and the growing reach of corporate influence. All eyes turned to the next move this time, from Justice Amy Coney Barrett and her colleagues on the bench. 3 weeks after Bezos's dramatic public announcement, the Supreme Court issued an extraordinary supplemental order in the United States versus Amazon Technologies case. Authored by Justice Barrett, the concise but powerful 5-page directive addressed not only Amazon's formal request to modify the ruling, but also the broader implications of Bezos's public-facing campaign. This court recognizes the right of any party to engage in advocacy concerning legal and policy matters, Barrett wrote, her tone measured yet unmistakably firm. However, the characterization of judicial remedies as mere suggestions, subject to unilateral substitution by private actors, reflects a fundamental misunderstanding of judicial authority under Article 3 of the Constitution. In no uncertain terms, the court rejected Amazon's motion to redirect the penalty into a private restitution fund. Barrett's order emphasized that allowing such an approach would effectively convert a constitutional court remedy into a corporate-governed solution beyond the judiciary's oversight, a precedent the court was not willing to set. Barrett's supplemental opinion served as a direct rebuke of Amazon's attempt to redefine the post-ruling narrative. It affirmed that, regardless of a corporation's resources or influence, judicial decisions were not to be reframed or overridden through PR campaigns or philanthropic counteroffers. Perhaps most strikingly, Justice Barrett addressed Bezos's public invitation for her future involvement in his proposed Digital Rights Foundation. While the court takes no position on speculative invitations extended to its members post-tenure, she wrote, any gesture that seeks to entwine current or former judicial officers with entities recently subject to judgment must be viewed with the utmost caution and concern for judicial independence. It was a moment of quiet but resolute pushback, a clear message that the court would not yield its constitutional ground, no matter how unprecedented or sophisticated the challenge. The independence of the judiciary demands not only freedom from actual conflicts of interest, but also from any appearance of entanglement with those who appear before the court. Justice Barrett wrote in the closing lines of the Supreme Court's supplemental order, "Members of this court cannot, and will not, be prospectively enlisted in private regulatory frameworks established by entities subject to our jurisdiction." With this unequivocal assertion, the court reaffirmed its constitutional authority and decisively rejected any attempts to blur the lines between private influence and judicial neutrality. The legal community immediately recognized the order's gravity. One constitutional law professor likened Barrett's response to a high-stakes poker player calling a well-disguised bluff, one that reinforced the institutional strength of the judiciary in the face of corporate audacity. But what followed demonstrated precisely why Jeff Bezos remains one of the most strategically agile figures in global business. Rather than resisting the court's sharp rebuke, Bezos executed a pivot so deft that it turned potential embarrassment into renewed opportunity. In a nationally televised interview aired just hours after the court's order, Bezos appeared measured and introspective, not defensive. "Justice Barrett is absolutely right in her interpretation of the separation of powers," he said with apparent sincerity. "My invitation, though well-meaning, was inappropriate. I appreciate the court's clarity in reinforcing those boundaries." Then came a striking turn. The court has made clear that neither government nor industry can address the complexities of the digital era in isolation. What we need is a framework that upholds judicial authority while fostering responsible innovation. In that moment, Bezos reframed the entire debate. He announced that Amazon would fully comply with the Supreme Court's ruling, paying the $1 billion penalty in full without further appeal. But more notably, he declared that the Digital Rights Foundation would move forward, now restructured as an independent public trust. Under the new model, the foundation would be governed not by Amazon, but by a coalition of consumer advocates, legal scholars, and technology experts. Amazon would have no controlling influence. The foundation's work, Bezos clarified, would explicitly respect judicial boundaries while exploring how private innovation could complement, not replace, legal remedies. The maneuver was executed with such skill that many failed to see its deeper strategic brilliance. While appearing to yield to the court's authority, Bezos had safeguarded Amazon's core interests. He retained the public goodwill generated by the foundation, shifted the company's narrative from accused to innovator, and preemptively shaped the regulatory discourse to align with Amazon's strengths. What followed was a masterclass in strategic adaptation. Amazon introduced a suite of new privacy-focused technologies that offered consumers granular control over their data without disrupting the personalized services at the heart of its platform. These features allowed the company to comply with the technical demands of Barrett's ruling while preserving the data-driven insights essential to its business. In tandem, Amazon launched a complete overhaul of its privacy policy. Dense legalese was replaced with clear, interactive consent options presented contextually at the moments when users were most engaged. The result: improved transparency, increased user trust, and higher rates of opt-in engagement, all while mitigating legal exposure. In the end, what began as a billion-dollar judgment and a forceful judicial rebuke was transformed into a strategic repositioning that strengthened Amazon's market leadership, reinforced its regulatory credibility, and elevated its standing as a thought leader in digital rights, all while publicly affirming the supremacy of the court's authority. The business world was left stunned by the sheer strategic precision of Jeff Bezos' response. He transformed what should have been Amazon's most damaging moment into a demonstration of why he remains the most formidable business strategist of the digital era, wrote one leading market analyst. Though Amazon fully complied with the Supreme Court's ruling, Bezos managed to not only safeguard, but strengthen, the company's long-term strategic position. For Justice Amy Coney Barrett, the resolution marked a nuanced kind of victory. The court's authority had been preserved, and the core principles outlined in her landmark privacy opinion remained intact. Yet Bezos had subtly redirected the implementation of those principles, away from a strictly punitive framework and toward one that addressed systemic concerns while aligning with Amazon's innovation agenda. As the dust settled, it became clear to observers across the ideological spectrum that this was not merely a legal skirmish, but a defining moment, a historic negotiation between two titans of modern American power: the judiciary and the tech industry. With Barrett and Bezos as their respective standard bearers, the confrontation quickly transcended the specific facts of the Amazon case. It came to symbolize the evolving relationship between traditional institutions of governance and the digital platforms now central to economic and civic life. Legal scholars began referring to a new jurisprudential framework as the Barrett Doctrine on digital privacy. Her majority opinion was cited for several landmark principles: that true consent in the digital age requires understanding, not just formal acceptance; that the scale of data collection can elevate privacy violations from isolated harms to systemic threats; and that penalties for violations should scale in proportion to a corporation's global reach, not merely its local impact. Meanwhile, top business schools developed case studies around what became known as the Bezos pivot, a blueprint for turning regulatory setbacks into strategic assets. Amazon's response was held up as a case study in corporate resilience, not just surviving regulatory scrutiny, but transforming it into a platform for innovation and reputational leadership. Despite the foundation's controversial origin, the Digital Rights Foundation evolved into a genuinely independent entity. Over time, it helped shape emerging global privacy standards. Its work on graduated consent, designing user-friendly, incremental choices rather than monolithic, unreadable agreements, proved particularly influential. This model came to represent a pragmatic balance between consumer autonomy and commercial functionality. For Barrett, the case solidified her reputation as a justice uniquely capable of applying classical legal principles to the complex realities of 21st-century technology. Her approach attracted praise from across the aisle. Progressives commended her defense of individual privacy, while conservatives respected her strict textualism and judicial restraint in remedy design. In legal and academic circles, the Barrett-Bezos confrontation ignited renewed interest in the question of governance in a digital age, particularly when private corporations rival, and at times surpass, the influence of public institutions. The case quickly became a fixture in both law school and business ethics curricula. It was studied not only as a test of judicial authority, but also as a masterclass in corporate adaptability, and, in many ways, as both. Perhaps most significantly, the Barrett-Bezos confrontation ushered in a new paradigm for resolving tensions between powerful technology platforms and traditional governance structures. Rather than following the familiar winner-takes-all trajectory that had defined earlier regulatory showdowns, the Amazon case revealed a path toward meaningful accountability, one that upheld legal principles while still fostering space for innovation. 3 years after the landmark ruling, Justice Amy Coney Barrett addressed the case publicly for the first time during an academic lecture on technology and the Constitution. Without referencing any specific litigants, she offered a nuanced vision for how courts should engage with emerging technologies. Barrett emphasized the enduring relevance of constitutional principles, while also acknowledging the difficulty of applying 18th-century legal foundations to 21st-century digital realities. The Constitution's enduring strength, Barrett remarked, does not lie in its ability to foresee every future scenario, but in its capacity to safeguard fundamental rights across generations of technological evolution, without impeding the societal progress innovation enables. Meanwhile, Jeff Bezos had integrated the lessons of the confrontation deeply into Amazon's long-term strategic playbook. Rather than merely reacting to future regulatory challenges, the company began proactively designing governance structures that embedded privacy, transparency, and user consent into its product lifecycle from the outset. It was a notable shift from regulatory compliance as a defensive measure to anticipatory governance as a competitive advantage. In what would become one of the most unexpected but consequential outcomes of the case, elements of Barrett's legal reasoning and Bezos's implementation strategy were eventually codified into federal privacy legislation. The new law struck a careful balance. It imposed clear, enforceable boundaries for data usage while allowing for continued innovation under a framework of responsibility and oversight. The bill passed with rare bipartisan support, a testament to the idea that even high-stakes institutional clashes can produce forward-looking governance models. What began as a legal standoff evolved into a collaborative blueprint for how courts, corporations, and lawmakers might navigate the complexities of the digital era together. For everyday Americans, the most immediate and lasting impact of the Barrett-Bezos confrontation was a transformed digital environment, one that finally began to honor individual privacy without sacrificing the personalized convenience users had grown accustomed to. The informed consent frameworks Amazon pioneered in response to the Supreme Court's ruling became industry benchmarks, empowering consumers with real control over their data without requiring technical fluency or legal savvy. As newer technologies, ranging from artificial intelligence to augmented reality, introduced fresh regulatory dilemmas, the Amazon case served as a critical precedent. It showed that America's legal and entrepreneurial systems, though often in tension, could operate not as adversaries, but as counterbalancing forces capable of refining one another. Neither judicial authority nor technological innovation was diminished. On the contrary, both emerged stronger through their engagement. The enduring takeaway wasn't about one justice or one CEO. It was about democratic resilience. In a functioning republic, even the most powerful institutions must engage in mutual accommodation, not by abandoning their principles, but by realizing that principled adaptation can often serve their missions more effectively than rigid confrontation. As the nation grapples with the accelerating complexities of the digital age, this foundational insight will be vital for navigating the challenges ahead. If you found this deep dive into the historic Barrett, Bezos case compelling, don't forget to like and subscribe for more thoughtful analysis of the legal and business shifts reshaping America's future. Drop a comment below. Do you think this case has permanently shifted the power dynamics between the judiciary and the tech industry? Your voice matters and helps us continue to deliver meaningful coverage of today's most consequential stories.